car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for making us a part of your Sunday evening. We certainly do not take that for granted, and thank you so much for allowing us into your homes. We have a panel of experts assembled ready to deal with the topic of conversation, specifically the Family Medical Leave Act that we believe is going to be pertinent to you and your life, and would love to have you join us in this conversation. Throughout the program, you'll see ways at the bottom of the screen for you to join the conversation. Also, do not forget, Hollis Wright makes available attorneys standing by live to speak with you about this topic or any other topic of interest to you. If you've got a question, they are there to answer. And leading our conversation tonight, as he often does, he's managing partner of the firm Hollis Wright. Josh Wright, good to see you.
Great to see you too.
Hope you're well.
Well, I hope you had a great week.
I did, thank you.
You know, we're coming back with new topics as the kind of spring rolls out, and this is one of them. I'm not even sure we've ever done a show on the Family Medical Leave Act.
Yeah, I'm not either.
And you know, David, there are a lot of circumstances where people end up having a major medical condition, and sometimes less than a major, but a chronic medical condition that requires them to be away from their job, and they have rights under the law, under certain circumstances, to protect their job and ensure that they've got employment moving forward. So we're going to talk about that today. Good. For those that are involved in this. We may even dabble into some of the circumstances where you involve workers' comp and kind of what happens if you're injured on the job too, a little bit today. Off topic, but maybe I'll address some of those things too. Allen Arnold's with us today, one of our guests.
Hi,
and
thanks for having me.
The expert, by the way, in this area.
Good.
This is a very unique area of the law. Not a lot of lawyers do this. You don't come out of law school and say, I'm going just to do FMLA work. So you also dabble in the employment context too, right?
I do. My firm practices almost exclusively on federal employment labor rights,
Okay.
which includes Title VII of the Civil Rights Act, the Age Discrimination Act, the Fair Labor Standards Act for unpaid wages, whistleblower claims that sometimes go to the Department of Labor. That's something a lot of people don't know. But also the FMLA, which is one of my favorite statutes because it's really about families and helping people after they've been hurt.
So you're part of the 5 Points Law Group here in Birmingham.
Yes, yes.
Tell us just a little bit about that practice. Sounds like it's a pretty comprehensive practice that you guys can service a lot of different areas.
We do. 5 Points Law Practice, our slogan is Lawyers for Life's Transitions. For me and my partner, Kyra Fontenot, we work as lawyers for working people, but I work with Burton Dunn, Kristen Sullivan, and Heather Fan. We do family law, elder law, wills and trusts and estates, and then the employment practice. But we're used to representing people, and that's what we take a lot of pride in.
That's great. So let's talk a little bit about the Family Medical Leave Act. First, just kind of explain in general, how does the statute and the law apply to individuals? Because this may be the first time people have actually heard that they're entitled to maintain their job under certain conditions if they have a major or chronic medical condition.
Well, the first thing you got to do is make sure your employer is covered by the law. Small employers, which is anybody who's under 50 employees on a regular basis, are not covered. So a lot of companies may offer maternity leave just as a benefit, but they're not entitled to it by law if they're under 50 employees. Now, employers with 50 or more employees on a regular basis, which the law defines as 20 or more calendar weeks, they have to provide unpaid medical leave for a period of up to 12 weeks, either on an extended basis or what we call an intermittent basis, which means periodic leave, like if you had to go to a physical therapist every week or needed to periodically go in for something that's terrible as chemotherapy, something that hurts, but you can still work. So it allows you to leave without penalty.
All right, so does Alabama have state laws if you're not covered, for example, with a smaller employer under 50 employees? Does Alabama have certain rules, guidelines, laws that may protect individuals outside of the Family Medical Leave Act? Because sometimes the states step in those circumstances. Now, I haven't seen one. I just didn't know if you've seen it.
They do, but not in Alabama.
Okay, gotcha.
We really need to actively lobby our legislature as citizens to add some additional state protections. There are a few holes in the Federal Family Medical Leave Act that the state legislature in Alabama could fill if they wanted to, but they need the political will to want to help the working person.
So what's your recommendation if somebody is with an employer that has 50 or less employees? Is it to be educated on the rules that you've got in maybe your employee handbook to make sure that you take advantage of that? I mean, what's good just practice?
Well, the good practice is yes, look at your employee handbook. Yeah. If you've never taken family and medical leave before, generally what you're going to need to do is tell your supervisor or HR person, hey, I've got a simple one, I'm pregnant. What do I do for maternity leave? The first time you tell your employer that you might need some sort of FMLA leave, you don't have to specifically mention the law. You need to give them enough notice of what's going on. Those would be, I've spent last night in the hospital and I just got discharged. I've got, my spouse just got deployed to go overseas to serve our country. Any sort of serious health condition that lasts multiple days and may have a follow-up visit. You just need to mention some of those key facts to get that. Now, here's the trick, and a lot of employees don't know this. Once you've used FMLA once, you're expected to know the rules. Yeah. And that's unfortunate because they shift the burden over to the employee for the second go-around.
Gotcha. Well, and that's important stuff because you know, a lot of times the employee handbook will fill the gap for small employers where there's not a requirement for Family Medical Leave Act. Somebody may have a protocol or a procedure already in place, like our firm does. We have a procedure in place if somebody has a major medical condition where there's a policy that we use and apply. So we're going to be held to the standard of that policy because that's what we put out to the employees. It said this is the rule of how we're going to handle it. So unless we make an adjustment as a law firm and notify the employees, we're going to be stuck going through that process for the most part. But you know, this statute is still a landmark statute that helps employees all over the country, and there are a lot of Alabamians that work for companies that are significantly greater than 50 employees.
Absolutely. Some good questions, and we love your questions to come in. You see that information at the bottom of your screen there, but a question here we have is, how do I know if I qualify for the Family Medical Leave Act?
Well, the first thing is you have to be there long enough. It requires 1 year of employee service, and you've had to have worked enough hours. It's not for the 5-hour-a-week part-time job person. There's an hourly threshold of 1,250 hours worked. And the employer has the duty to track that. And they have the duty, once you raise the issue that you might need FMLA, to make sure you hit that threshold. But you have to be there for 12 months and have enough hours worked. The 12 months don't necessarily have to be continuous though. And an employer sometimes mess that up. So know that if you worked, for example, at Six Flags for 7 months of the year for 2 straight years, you've hit your 12 months. Have you worked enough hours now is the question.
I know we're getting ready to go to break. When we come back, let's talk a little bit about whether or not that is on a yearly basis or whether or not it's every other year, how that kind of works. And I think Allen will be able to walk us through that.
Good deal. Let's head to our first break of the evening. As we do so, reminder, social media, Hollis Wright is all over it. Facebook, just search the term Hollis Wright. You'll find them there. And also on Twitter, Hollis_Wright. Great educational, informational resource for you. Check out Hollis Wright right there on social media. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into The Attorney, talking all about the Family Medical Leave Act tonight. Really appreciate you being with us tonight. A reminder that while the show is on the air, so about 20 more minutes or so, attorneys from Hollis Wright standing by live right now to speak with you. So be sure to take advantage of that opportunity. And Josh, maybe the conversation or the questions are about the show we've got here. They sometimes run the gamut, don't they?
Well, they do. And, you know, a lot of times we'll get questions that are very specific to the show, and Allen is helping us answer those questions today. As you know, David, there are a lot of things that are not within the sweet spot of what our firm does, and one of the things that we pledge to folks is we answer every call, text, or email. Even if it's not in the sweet spot of what our law firm does, we're going to get you to an expert that knows what they're doing. So if it is a divorce-related issue, we're going to get you to a divorce lawyer or someone that can answer that question. You're going to get a live lawyer answering your question regardless, but we're going to get you to the right person. And so, you know, people sometimes take us up on it and wonder whether or not we actually do call people back or whether we actually respond to texts and emails and Facebook posts and Twitter posts. We do all that stuff, and that's our way to give back to the community. I'm very proud to say after 6 years we have continued to answer every call, email, or text that's come in, and I think it's been a good thing and a good service for the community without question. Hey, one of the facts, Allen, that I thought was good, that when we came back in from commercial, it indicated to me that the Family Medical Leave Act is working. It said that 90% of those that use the FMLA return to their place of employment. That tells me that the act is actually working pretty well. For
the most part, it is working, and it's one of the most popular acts Congress has ever put out. It was written in 1993. Ted Kennedy and Bill Clinton later signed. Ted Kennedy wrote it, Bill Clinton signed it, and it has gotten to the point now where we as a culture expect it. As a matter of fact, we're already moving to the next level, hopefully, of getting to some paid family leave. Now, how they're going to work that out, we don't know. But it is a popular act. People are used to it, expect it, and know that they can keep their job. They don't risk losing their job for caring for a parent, a child, having a baby, adopting a child even. They get time to do that without penalty.
One of the things I was going to ask you is what applies? I know that we can't define everything in the statute for every medical condition or issue that you face in life that's going to apply to the Family Medical Leave Act, but give us some examples. Like, you know, if you have a terminal cancer, that's something that applies. You mentioned a couple just a minute ago. I mean, what's the general rule of how someone can find out what applies and what doesn't apply?
Well, thankfully, there isn't a specific term of what an FMLA qualifying condition is under like a medical definition. It's defined more about the nature of the treatment and how you're treated. The most common example that I see in my practice are people who spend well, frankly, we help people who get fired because they use their FMLA rights. And the most common one usually is when somebody has a serious health condition that doesn't land them in the hospital. Something where, for example, you're incapacitated for 3 days in a row because of the flu. And you mean you can't get out of bed, and you're ordered to certainly stay at home to not spread it. 3 consecutive days of treatment is what should start making you think, am I protected by the law? That would be the first thing to look at. But I've seen it doesn't cover the common cold, and it's not going to cover a sore throat, but it's going to cover things that, if it sounds serious, it is serious, and it's probably covered.
One of the things I wanted to ask you, you mentioned early in that first segment about some of the areas that your legal practice cover. Even if you don't fall under the Family Medical Leave Act, but you feel like you may have been discriminated against because of a condition, for example, a pregnancy, there are other laws out there that help kind of assist you and protect you under circumstances that may come up in life.
Absolutely. So the Pregnancy Discrimination Act, which is part of the Civil Rights Act of 1964, covers pregnancy and pregnant-related conditions even after you have the child to be free from discrimination, and that is smaller employers. It only takes 15 employees or more to be covered by that law. And the Americans with Disabilities Act also can cover, would fill that gap a little bit depending on what the nature of your condition is.
Yeah, so a good example of why, if you've got an issue at work related to medical care, pregnancy, a changed circumstance in life, you want to get to guys like Allen to be able to answer kind of where your protections are. And a lot of times it's probably just a call saying, here's what's going on at work. They have not terminated me yet, but what are my rights? Understanding what those rights are.
A question we've got here, can I work another job while I am on FMLA? Can you get another side gig?
That's a good question, and yes, you can. There is part of the regulations that the Department of Labor handed out does allow for, if you had two jobs at the time you go on leave, you can continue working that job. Now, if you go get a new job during that time you're out, that's probably not going to be covered, and that's not the purpose of the statute. But if you worked a full-time job at one of the factories, one of the car factories, but you also worked on the weekends at a grocery store or a gas station, you can continue working that grocery store and gas station job. But don't go out and find a new manufacturing job at a different plant. It's not your opportunity to look for something better.
What's the interplay between requiring use of vacation and sick time versus unpaid family medical leave time? How do those interplay with each other?
The employer, if they so choose, can make you take your vacation pay and your sick time concurrently with your FMLA leave. Okay. Now, some of the burdens they'll put on you about reporting in while you're on vacation or while you're on sick leave, and the burdens they have under the FMLA, those things have to kind of combine together. Okay. So if the burden is lower on the vacation, they can't raise the burden for FMLA. But if the burden is high, it doesn't work the other way around.
Well, and one of the questions I'd ask then is, if you're sick and your vacation time comes with compensation, are you entitled to still maintain that compensation during your family medical leave time?
If you've got the time, you can get paid. But once the bank of paid vacation days or 6 days runs out, all they have to do is promise to hold your job for up to a period of 12 weeks, unpaid.
All right. Let me ask you a question about pregnancy. How does the Family Medical Leave Act work in terms of pregnancy as a condition that could get you some time off?
And does it apply to husbands too? I'd like to know that, because that's an issue that comes up sometimes.
Well, big question. Yes, it does. It does apply to paternity leave. One of the purposes of the statute was to give fathers time off so they could be involved in the birth of their children, so they could be there. You don't even have to take the leave immediately. You can take it up to any time within a year of that paternity leave after the child is born. In terms of pregnancy leave, it can apply to pregnancy-related conditions that occur before the child is born for the mother. If it's a high-risk pregnancy, or there are reasons to go in for, and I don't mean regular checkups, but if there's some sort of serious issue that's related to the pregnancy that requires periodic visits to the doctor, those are covered too. This brings up an important point though. One of the things you've got to do is you have to work with your employer about certifying your medical leave. You've got to talk with them about getting your physician to sign off on it, explain what's going on, the reasons for the leave, and you've kind of got to work with your doctors to make sure they get this paperwork filled out, because there are deadlines involved, and doctors aren't always good with deadlines.
Hey, so when we come back, because I know we're getting ready to go to break, I want to talk to Allen a little bit about, if you feel like you have been discriminated against, if you have been terminated under these circumstances, what do you do? When do you get to a guy like Allen? When do you ask about your rights? When do you have that evaluated, and how does that process work? Let's talk about that when we come back.
Good deal. That's a good spot. We're going to pick up right there whenever we come back. As we head to break, a reminder about the attorneys standing by live from Hollis Wright. For the next few minutes, they're going to be there. Take advantage of that opportunity to get some free, confidential, off-air legal advice. Stay tuned. The final segment of the attorneys coming right up.
I'm attorney Bobby Bell with Hollis Wright Law Firm. In today's world, social media is all around us. It is common for many people to post on social media regarding their life and activities on a daily basis. Facebook, Instagram, Twitter, and similar social media are a great way to stay connected to others and to share your experiences and thoughts. Some seemingly innocent social media posts, however, can have devastating effects if you're involved in litigation, especially in a personal injury claim, a contested divorce, or a child custody battle. Courts regularly allow adverse parties access to the other side's social media accounts, allowing relevant posts to be presented as evidence. These rules have allowed social media to become a hotbed of information in the litigation world. In fact, we are seeing more and more preservation orders issued by courts requiring you to collect and save any and all social media activity. Therefore, it's advisable that even before there's litigation, lawyers should advise their clients that social media content may be discoverable. Here are a few helpful tips. 1. Do not post anything about the case. This includes posts regarding conversations or meetings with your attorneys, remarks about your injuries, negative remarks about the opposing party. Do not post anything you would not want read in open court to either a judge or a jury. 2. Avoid new friend requests from people you do not know. Many law firms and insurance offices may attempt to have employees follow you on social media in an attempt to gain information. 3. Limit adding new photos, check-ins, photo tagging, etc. Seemingly innocent posts may be used against you. Regular check-ins at restaurants, parties, or other events with friends can cast doubt on any claims of loss of enjoyment of life, pain and suffering, or emotional distress, since you appear to be living life as usual. 4. Increase your privacy settings. Many social media sites frequently update and change their privacy settings. In the litigation context, it is possible you may have to preserve and present anything you posted. Therefore, we encourage you to be smart and careful when using social media. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WBTM 13.
What is justice? Justice is fairness and the belief that you will be heard in tough moments. At Hollis Wright, we strive to achieve justice for people experiencing injuries and loss of life. Often, justice is not easily obtained, but we work hard every day, no matter how difficult the challenge, to seek justice for our clients. If you've been hurt in an accident or lost a loved one, know that Hollis Wright will seek justice for you.
Welcome back into The Attorneys. About 7-8 minutes remaining, so if you want to take advantage of that opportunity to speak with an attorney from Hollis Wright standing by live, you got just a few minutes to do it, so don't miss your chance. Josh?
Hey, what was the firm fact that just came back in when we went to break and it was coming back? What is the certification form?
That's what I was talking about a minute ago, where you've got to get your physician to fill out a form certifying that you've got an FMLA qualifying condition. The employer is supposed to provide that to you, okay. And sometimes that doesn't happen. If it doesn't, you can go to the Department of Labor website and literally Google the form and it will pop up in a PDF and you can fill it out and take it to the doctor yourself. But most employers do the right thing and get it to them.
Is there a way to determine whether your employer falls under the FMLA without going to the employer? Like, is there a website, a labor website that defines who's who? Or is it really just a matter of assessing how many total employees you have?
The simple answer is look in your handbook. Okay. If you're FMLA covered, the handbook is supposed to have it in there. Gotcha. And then if it's not in the handbook and you want to be doubly sure, check that poster in your break room that tells you about your labor rights. It's going to be sitting up there, and usually if you're an FMLA covered employer, you've got it, and if you're not, the employer's not going to try and add extra burden.
And a lot of people don't realize those posters that come, we get them too, they come from your insurance company. So a lot of times you're funding your insurance as an employer through an insurance company that's helping you, for example, workers' comp and whatnot, and those posters are sometimes coming from your insurance company. So that's another way, is look at the poster to determine, you know, they may be insured by somebody that's helping with some of this FMLA, but it's going to probably be posted.
That's true, and sometimes those insurance companies even manage the FMLA program, and they're the person you actually contact for your certification, your paperwork, and approving and disapproving the leave.
Now there's something you did not know.
I did not know.
You did not know. All right. Let's get back on top of that. I want to ask you at the break this question. Explain, if you will, how a lawyer gets compensated, because I know there are people sitting on the couch right now saying, hey, I really want to talk to this guy, but I'm nervous that I'm going to have to pay a fee or pay an hourly to do that, but I think I'm being discriminated against. How do you respond to that to make sure they realize that, hold on, your fees are covered through a different source?
Our fees are covered through the way the statute's written. We work on a contingency fee basis, and one of the things that allows us to recover our fees is we can petition the court, if we win a judgment in favor of the employee, to have the employer pay our fees for us.
Even if it's on a contingency, that means that you front the costs and expenses and they get your legal time notwithstanding.
That's correct. I've never had an employee pay me anything.
Okay, and that's super important.
It is.
Because people don't realize enough, and we just gloss over the concept of contingency fee, or gloss over the concept that the statute allows the employer to pay the fees. People sometimes may not grasp the concept. It's really critical that you can get the same quality of legal service on the plaintiff side or the victim side that you can get in the corporate America side because of statutes like that, because of contingency fee arrangements where you don't have to front a cent to your lawyer. You go hire the lawyer, right. He handles the case for you. If he's successful, he's able to be compensated too. That's super important. I want people to recognize that.
Yeah, relief for a lot of folks, I'm sure. We've got just about 3 minutes remaining, but want to get this question in. What about whenever I come back to work, will my job be the same?
They only have to provide you, employers only have a duty to provide you with a comparable job, not the same job. They've got to keep similar working terms and conditions. So if you left at $14 an hour and they brought you back at minimum wage, that's interfering with your FMLA rights. Right. But if they moved you from first shift to second shift, that gets a little hazier. They have a duty to provide you with a job, to hold a job for you within those 12 weeks.
Okay. And one other one real quick, how about the families of military personnel? When are they eligible to use FMLA?
They're eligible to use it for deployments, and when a soldier is deployed, the family members have a 7-day period to get their affairs in order before that soldier or sailor goes off to wherever they're going, to get their, to manage, so the family can take time off for managing their finances, figuring out child care, that sort of thing.
Interesting stuff too, that doesn't necessarily apply to medical care. It applies to leave that's necessary to be able to get things correct and your affairs in order to allow them to ship off.
Well, gentlemen, appreciate the time.
Good job, as usual.
Nice job. Appreciate you being with us and you being with us as well each and every week. Thank you so much for that. As we wrap things up here, a reminder, Hollis Wright, they answer every call, text, and email. So even if you get in touch with them after the show is over, they will get back in touch with you. We appreciate you being with us each and every week. We'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.